attached to a suspicious vehicle call at 11,000 block of Grant Road in Harris County, Texas. The wheel witness stated that the defendant was observed in the driver's seat, slumped over with her eyes closed and slowly approaching the intersection. The witness followed the defendant's vehicle and was able to get her to pull over at Cypress Creek High School. The wheel witness believes the defendant was having a diabetic medical emergency. The defendant then left the location and drove on the wrong side of the road. The witness identified the defendant's vehicle, and the officer located the vehicle, and a traffic stop was initiated to check on the well-being of the defendant. Upon making contact with the defendant, the officer immediately detected an odor of an alcoholic beverage, slurred speech, and the defendant was unable to maintain balance. She admitted to drinking one alcoholic beverage. EMS arrived, and the defendant was cleared. SFSTs were conducted. It was a 4 out of 6 on the HGN, a 5 out of 8 on the walk and turn, and a 1 out of 4 on the one-leg stand. The DIC was read, and she consented to breath. The results are a .214 and a .205.
Do you mind running her NCIC, please? And then whether she has a license?
Yes.
Ma'am, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Your Honor.
She has a New Hampshire driver's license. It does not look like it's eligible.
You do
And
not have a license?
I do have a license.
You have a Texas driver license?
No. I have a New Hampshire driver.
It's not eligible. They're looking at the screen now. So you're not allowed to drive. It is your responsibility to get in touch with them to see what you need to do to get it back. But until that point, you're not allowed to drive.
Your Honor, I'm sorry. I think I misspoke here. It looks like it is valid. It's a little bit different to read than Texas flood, so
Okay.
excuse me for that, but
Not a
it is
problem.
valid.
Okay, unless you have a valid license and liability insurance, you're not allowed to drive. You need to have car insurance. Do you understand?
Yes,
If I
sir.
find that you drive without it, likewise, I'm going to revoke your bond, put you in jail. No more PR bonds for you. Tell me, ma'am, do you have the ability to hire a lawyer? Okay, I will have you fill out an application. We'll look to see whether you qualify. For now, I'm gonna have you, shit. For now, I'll have you go to Victoria, sign a reset. Deputy Miranda's gonna give you an application. I'll have you eventually meet with Fleischer for your bond conditions, and then we'll have you take your signature box, ma'am.
Yes, sir.
You're Freddie Perez?
Yes, sir.
Mr. Perez, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 10th, 2025, officers initiated a traffic stop at 4841 block of Mount Houston Road in Harris County, Texas. Numerous vehicles were observed inside of a parking lot in a pit. The officer observed the defendant driving a white Honda, engaging in reckless driving by doing approximately 4 donuts. The defendant's vehicle was coming close to hitting people standing by the pit and other vehicles as well, disregarding the safety of the other people and their property. The defendant was the only occupant of the vehicle.
She's the only occupant.
Yes.
Okay, can you run his license, please?
Right. Yes, Your Honor.
Mr. Perez, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to drive in a reckless manner again, not to do donuts, street takeovers, racing, any of this nature. If you do, first I'm going to put you in jail. Next, I will take your ability to drive away from you. Do you understand?
Yes, sir.
It's valid, Your Honor.
All right, you're not allowed to drive unless you also have valid liability insurance in your name. That is a condition of your bond as well. So if you don't have car insurance, you're not allowed to drive. Do you have a lawyer today?
No, sir.
Do you have the ability to hire a lawyer? I'll have you fill out an application. I'll see whether you qualify. Do not leave until you sign our bond conditions. Deputy Miranda's going to give you an application. I'll have you sign a reset with Victoria, and then we'll have you take your signature box.
Can I just say something? I want.
No. Don't. We'll talk later, please. Thank you.
With this one, go ahead and sign for the reset, please.
Okay, yeah.
I got 2, Judge. Gonzalez is the first one. We had spoken about both of these guys about 2 weeks ago. It's a piece of item. They've both, well, he's done the TRAS. We've emailed the application and the mitigation. We're waiting on, Ashton, guys, for a decision.
Sorry, which Gonzalez?
Diego.
Diego. Got three today.
Sure. Only three?
Uh,
And if you remember, Judge, when we were here last time, we've already done the TRS, already done the app, and then for some reason, I don't know if there's a change across the board or what, but all of a sudden we needed to do mitigation. So,
Right.
and you were like,
You turned it in when though? I mean,
26, March
Right.
6th.
so it looks like we do have it, it's pending approval. I can send an
Right.
email to her and see if we can get an answer
Sure. Okay.
soon.
Yeah, let's do that. It's on Gonzalez. Who's the other one?
Guevara, Guevara. This one, Judge, we didn't, as of last time we were here, we didn't have the letters, but we have them now and we're submitting them today. Because this is the one,
150.
Judge, we did the TRES, did the application, then all of a sudden they changed it on us and said, you have to get us everything. So that,
All right, so you have everything to turn in today?
yes.
All right, so let's set it a week.
Okay. Do you want to do a week on each one?
No. Let's see, because everything's turned in on Gonzalez. Let's see if she has a response on that, and then on Guevara, we'll set it off a week.
Okay. Can I waive Rivada's appearance, Judge? Because he keeps missing work every time. They're both here. Okay, thank you.
It doesn't say name, Your Honor. Would you like to read it?
No, I don't want to look at this paper.
Okay,
I'd have like,
sure.
but we have to do probable cause. I've got my- not filed any documents here.
Pase aquí adelante en sus papeles allá. Parece aquí, hermanito.
Wait a second, I do see something filed.
Where? For Munoz?
Acérquese, solo mire su señoría. Está en español
This is
nada
Mr.
más.
Opara.
Señor Oparra.
The messages.
Oh, you just got it?
Yeah, I guess, okay, so they do have paperwork that's been, so just go ahead, take a seat, do not leave.
No se
And
vaya.
then we'll do probable cause as soon as your lawyer gets here.
Sí, tomen
Do
asiento.
not leave.
Pero no se vaya, por favor.
You ready?
Yes.
Is there someone else or is that it for Luis?
No, that was.
Okay, that's it, man. Thanks.
No.
Okay.
I'll speak English.
Ready?
Yes, Judge. Miss Olivera Catherine. With a K, Olivera. Arraignment.
Ms. Olivera, come up.
I don't know if this was regarding.
Yes, I'm not in the market.
You are Catherine Olivera. Ma'am, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, ma'am. Okay.
On March 10th, 2025, at approximately 1 a.m., officers conducted a traffic stop at the 16,000 block of Katy Freeway on a white Lexus for speeding. The officer paced the motor vehicle traveling 85 miles per hour in a 60 miles per hour zone for approximately a quarter mile. The motor vehicle was also failing to maintain a single lane. The officer made contact with the defendant, the driver. The officer observed a strong odor of an alcoholic beverage, slurred speech, red glassy eyes, and the inability to balance. The defendant admitted to having 2 drinks prior to driving the motor vehicle. SFSTs were conducted. It was a 6 out of 6 on the HGN, a 5 out of 8 on the walk and turn, and a 1 out of 4 on the one leg stand. The DIC was read and she consented to breath. The results were a .187 and a .185. She was identified by her driver's license.
So any prior WIs and then
No prior to WIs, her license is eligible.
that. All right, Ms. Olivera, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming, I will revoke your bond, put you in jail. No more PR bonds. You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with him, and he'll tell you if and when you have to come back to court. If I find that you pick up a new case, you're driving without insurance, anything else, then it's not going to go well for you. I'll have you sign a reset with Victoria. We'll have you get with Fleischer for your bond conditions, and then you're free to go. All right?
Thank you, Judge.
Thanks, Mr. Nolan.
Yeah, she emailed me late last night and she's sick. And so she just asked if I can approach to get a new date and if we can just push it a little bit past. We're set on our April the 10th for the felony. We're working on trying to get some resolution, Judge. We had some resolution. We were working on some resolution.
All right, oh, or the day after?
Yeah, I mean, we can even come down if you want, on
You
that
want the
day.
you want the day,
Yeah,
the same day?
We can just come right down
Okay.
and.
Yeah, no problem. Yeah, just tell them to be good, that's it.
I'm sorry?
Just be good, that's it.
Oh, yes, sir. Yeah, I think,
Hit,
I got it, Judge. Thank you.
have fun.
Thank you.
You said Kamisha Johnson?
Yes, is that how you pronounce your name?
Yes, sir.
Yes, yes, Demetri Johnson.
Appointed on the case?
Yes,
Did you just get appointed to the case?
got a point today, Judge.
Okay.
Judge, we already filed PC and did bond condition.
Yeah, that's, I thought we did.
We're just waiting on council for a reset date.
Okay. Yeah, you're good to go. Just, ma'am, don't drive. Above all else in the short life that we have, don't. I don't care what your justification is. If you drive, it's really not going to go well for you. Do you understand? All you got to do is get your Texas driver license, liability insurance, show us that you got it, and then I'm happily take all these conditions off.
Can I ask a question? If I do my occupational license, thing, could
You
you?
need to call DPS first, because if you've never had a license, that's going to be an issue. So you need to call them first to see what you need to do. Don't just try to apply and start spending 150 to, it's,
I went there, that's why I have asked you.
don't just start, I can't give you legal advice. The only thing I would say is go to DPS, call them, and they can tell you what you need to do to actually get your license. Why are you going to pay all this money to get an occupation when you should go get your regular license?
Because on the chart, it says that I have to have an occupational for like a amount of time in order to release the license.
I don't know if I would grant you one. I really don't. I'd have to look at a lot of things. First things first, though, is call DPS. This is the number of the driver's license division. Call them at 7 a.m. Otherwise, you'll never get through. Don't call at 8:01, 9:32. You'll never get through because the phone lines, you have to call it right when they open, which is at 7. Call them and figure out what you need to do to try to get it back. And that's what you need to do first and foremost. Okay?
Great. Thank you, Judge.
All right.
Good
Good morning.
I'm here on Darren Cassidy. He's in custody. I'm just approaching on a bond reduction, Judge. As for discovery, on the new case, nothing is in. On the older case, the body cam is in. The state wants to reach out to the complaining witness on the newer case before they make an offer. So that's where we are discovery wise.
Okay. What do you want?
He's asking for PR bonus, Judge. Oh, I'm just doing my job.
I know. He doesn't show up though. He never, it's 4 times he's taken off on us.
Would you consider a bond in the amount of $500 on each?
State. Cassidy.
Yes, Your
She
Honor.
wants a $500 bond on each. What do you think?
Your Honor, I think the state's concern is just, we've got a new charge here. This one is allegedly.
What you say in the home?
It's a personal property. I think it was the yard, but, not part of the hat. But, Your Honor, I think the state is concerned that he's taken off a lot.
The first one we have is 1,010.
Mm-hmm.
If you want, I'll do, 1,013 on both. So I know that it's, or 1,003 on both. So I know, but I can't possibly give him a PR. He just doesn't show up.
Understood, Judge.
But do you want that?
Sure. Thank you. That's all I have to.
So, my name is Judge Fleischer. How are you doing? I have Jonathan Lopez on docket today. It's a violation of bond conditions. After speaking with him and looking at it, it looks like he signed for bond conditions on March 5th, and that was filed on March 5th, and that stated an address. However, another bond condition, an amended bond conditions, was filed on March 10th with that address crossed out and a new one added in. He wasn't aware of that, and that's the address that he went to for this violation of bond conditions. He's here.
If I needed to, this was the case
Yeah.
where we came back for a minute Moab. Brad was the attorney on it. We came in, we scratched out the old address. It
Council for
looks like,
reset.
based on what I saw, his client had initialed it, Brad had initialed it, and we as the state had done it. And it looks like as soon as he got out of jail, he went to that address.
He's not aware of those. Let me pull it up.
So you're saying he did?
Yes, Judge. On the amended book, there's his initials on the amended book, as well as the attorney.
I'll advise him. He was stating that he was unaware that that's why he was initialing. I told him I would address it with him, but it's a presumption that he knows what he's signing. But I did tell him that I will bring it to your attention.
Does he want?
He's just basically saying that he didn't know what address that he was supposed to be prohibited from. He was under the impression that he's still supposed to be prohibited from the 20915 Bar Street and not Owens. I told him I would address it with you.
Okay.
We could bring him out if you want to.
I don't know. It's up to you. I mean, if you want to, but it looks like he's got a high bond on the felony case, huh?
Yeah.
And he's not made bond on that case, so he's got a high bond on our case as well.
And Your Honor, I think that's actually, so there's two Jonathan Lopez on the docket. One's a VPO.
Oh,
Sorry, Your Honor. I know what case you're talking about too. I was,
I see.
Oh, this one is just a misdemeanor. This
I have literally two Jonathan
and
Lopez's.
Lopez's. Yes.
You're wrong.
I have Santos.
Your Honor.
That's why.
So this one, no, he just has this VPO. I did talk to the state. I understand the concerns. I just wanted to bring this to your attention because he's saying that he was unaware of the change of address.
I told him over and over and over. Can you bring him out? Jonathan Lopez? Santos. Here. Hold on, let me make sure you get the right one. Bottom of 38, yeah. If he tries to tell me that he didn't know, I mean, how many times did we say?
Well, this is the case where the plea was re-entered after the MOAB was amended, so then you advised him, admonished him once more.
Yeah. I told him I would bring it to your attention, Judge, so.
So this is the one where we did, we did the plea on the terroristic threat, right? The terroristic threat, the evading were dismissed. Or two terroristic threats and an evading were dismissed, right?
That wasn't with me, Judge.
Yes, Judge.
Okay, so, no, it was just one terroristic threat.
One terroristic
Yeah, it was
threat.
just one. How's jail? Some just don't get it. I mean, I'm truly at a loss. Truly at a loss. When we did the plea, not 6-7 days ago, I told you probably 25 times, don't go back. And now here, you've picked up a violation of a bond condition of protective order. Let's do probable cause because I don't know. You have the right to remain silent. Anything you say can or will be used against you, sir. Please.
On March 12, 2025 in Harris County, Texas, officers were dispatched to a violation of a protective order call. The officer met with the complainant who stated that she found the defendant in her mother's house while there was an active protective order, including a residency restriction. The officer arrived and found the defendant at the location to confirm there was a protective order prohibiting the defendant from being at the location.
So it goes back to mom's house.
Yes, sir.
Not the.
Yes, sir. She went back to the residence.
I don't know what we're gonna, I don't know,
I just want to make sure that he knows or that I wasn't there on the plea before. I just seen that the two different filings. He's saying that he didn't know the address.
Problem is that we have the wrong address.
Right.
So we amended.
So, but he was unvarnished about the new address.
And so far as the lawyer even went to the jail to go talk to him.
Okay.
To tell him. So I did,
Okay.
the lawyer did.
Okay. Well, thank you, Judge. I didn't know that.
I don't know if you're gonna get out, but let me tell you something, and I want to make this really clear to you, Mr. Lopez, is that now, with what you were charged with, the Texas Constitution does not allow me, but in extremely limited circumstances, this being one of those, to have a hearing to hold you at no bond. Zero bond. This is that type of offense. I don't know if you're gonna get out. I don't know if anyone is gonna pony up the $5,000 to get you out. If someone does, I'm going to put an ankle monitor on you. If I find that you violate any of the conditions that I'm going to put on you now, I will have a hearing to hold you at no bond. Do you understand? I don't know what it's going to take to get you to hear me, but perhaps that may be it. I don't want you to have any contact with the complaining witness in this case. I don't want you to have any contact with mom. I don't want you to have any contact with dad. I don't want you to have any weapons. I don't want you to go within 1,000 feet of where they live, or where they work, and the address listed in this order for protection. Do you understand?
And I have the address, sir. The correct address.
We will give it to you. Prior to me, I'm going to tell you this now, Ms. Strong, that prior to me accepting anything, any kind of plea bargain in this case, I would like to have a TRAS done to see how we go forward. Because I'm going to tell you now that every time that something, and,
I understand, Judge.
okay, all right.
Absolutely.
Okay, so we need him to sign conditions real quick, and then we'll give him a copy of the MOA right here, and then he can go back.
Thank you.
Sure, and I'm gonna find probable cause as well.
Okay.
Ready? Hey,
I have a couple for you. The first one is Crystal Gonzalez.
okay,
She's in the process of entering the PTI program, but the state is still waiting to speak to the complaining witness. From my understanding, she's a Spanish speaker, so they've had a little hard,
240 days, you say, really?
Yeah.
I mean, we've been working on mitigation the whole time, I don't,
Yeah, Judge, let me see what the current status of that is.
her mitigation packet is in.
Okay, let me just. Yes, Judge. So the only reason we would want to speak to complainant just for restitution purposes, and we haven't been able to thus far, and I can talk to my chief to see if what we can do as far as getting in contact and what to do in the absence of that.
okay, so Gonzalez, it's 240 days. Yeah, I'll give you guys a week to figure out what to do. Other than that, just, we'll go forward without. Crystal Gonzalez. The problem is restitution from, and it's a Spanish speaker, so get it to a investigator today, please. Okay?
The next one is Luis Salazar, and his supervision order is ready.
Okay, I'll sign it. Wonderful.
And then I also have a motion to sub for Marissa Wilson.
That's Senate free.
She also has a bond violation, for today.
Last name Wilson?
Yes, sir.
Yeah. Sometimes I feel money.
It's time to figure out, this case is 200 days old.
Okay.
It's time to figure out what we're gonna do.
Yes, sir.
She's been denied PTI, so it's time. I mean, she's got a bond violation. It's, please.
Yes, sir. I anticipate that we're gonna be accepting a probation offer.
Okay.
But I do need a little time to speak with her.
Yes, take your time. No rush.
Can we get a reset for this one?
No, she's got a bond violation. It's 200 days old. That's why. I mean, I'm sending her for a drug test now.
Okay, I'm not sure if she's present right now, Your Honor.
She's supposed to be here, because if she's not here, I'm going to revoke the bond. Because we sent.
Well, I sent her something.
Oh, you did, great.
Yes,
Do you have-
she should be on her way back.
Do you have results?
I will double check.
So let's hold for you to get to her.
Yes, sir. Thank you.
Omar Syed.
Fix your collar.
Jacket or?
Sure.
No, I just don't have shirts that he's in there today. Can I approach?
I'm live streaming, so I don't know if there's something you want to say. Well, let me see how old this kid is. So I'm going to give him a week to do it. If he doesn't do it, I'm saying it for trial. You know, it's about him just walking in and doing it, right? Come up, Mr. Said.
Hello, Your Honor.
Do you know what your lawyer had worked out for you to do, sir?
Today?
No. What you were supposed to do between the last setting and today, what were you supposed to do?
They told me I needed to go to a mental health evaluation or something like that.
All you had to do was walk in, tell them that you're there to do it, and then they would have done the assessment.
Okay,
I don't understand why it never got done.
I would suggest not a reason because he's going to give you a week. That's my suggestion.
yeah, that's all I need. Okay, so,
Your case is 250 days old.
yes, sir.
Unacceptable that it's gotten this old.
I know, sir.
I will give you a week. If you
Thank you.
don't have it done in a week, I'm going to set your case for trial. And I'm not giving you any more resets.
Okay,
You'll be put to trial.
that's good enough, sir.
1 week.
Yes, sir.
If you
Yes,
don't
sir.
understand what to do, Mr. Newman can help you out.
That's why I have.
Just no more excuses.
Okay, yes, sir.
Thank you, sir.
Thank you so much.
I'll get you a reset. Pardon one of
Yes, ma'am.
I'm here today on Carl Lee Powell. He's in custody. It's a bail review setting. He has a felony attached, and I spoke to DVD about the situation. And it is a little confusing because it appears when he was in felony court, the residence that he's supposed to stay away from is actually his mother's residence where he lives. The complaining witness is a roommate that he let a gentleman and this gentleman's girlfriend move in with him. And so
In her house.
in her house with the mom. With the mom. And then the allegation is that the complaining witness stated that he, assaulted her on a different occasion. And then that's when the charges were filed. So,
Complaining stated that Mr. Powell.
yes,
Okay.
assaulted her.
Okay.
And then charges were filed and he was given bond conditions. And at that time, like January 31st, a MOAT was signed. Okay. And he had an ankle monitor. But the complaining witness then went to a rehab facility for crack addiction, I believe. And so when she was out of the house, he goes back to felony court. I mean, he goes back home. He goes back to felony court. The judge allowed him to amend the bond condition so he can go back to that residence.
Sure.
Yeah, that's when I spoke to DVD, but the problem was the MOAP was still in place when he went back to the house. So I think it's a violate bond condition and a MOAP, but since that time, I guess, when he spoke to Judge Peebles, that he amended the bond conditions, removed the ankle monitor, and allowed him to go back home. In this court today, the violate the protective order is alleged to have occurred that the complaining witness went to the house where his mom lives to get her stuff because she was told she had to move out because her boyfriend now is in custody for a different offense. So she was asked to leave the residence. The mom didn't want her there. So she goes back to get her belongings. And that's when she encounters Mr. Powell's in the house because he's been living there with his mom. And so she does state, I think, in her, in the probable cause that he did not threaten her or he did not assault her, but here we are. I mean, it's a black letter law, right?
Yeah.
So obviously, I think everything's going to hinge on the felony case.
Yes, Judge, and we have notes as well saying that the felony court did remove that condition. It's just uncertain why they didn't amend it in the MOAP as well, but the bond condition was removed after it was found the complainant no longer resided at the.
We're holding him at no bond too.
Right, so.
I don't understand how.
And then that's what I'm saying. And he does go back to court on the 19th.
No?
For the
I mean,
felony.
with our case, the problem is that he's still in communication with her, which is still a violation, right? You can go back to the house, you just can't, I mean, and I'm assuming the only reason he could go back to the house is because she's in rehab and she's gone, right? But for her being in rehab, he still wouldn't be able to go there. Because I think the idea is that they don't have communication together.
And I think the
Problem
date
is-
was the February.
And
Yeah.
what I don't, the problem upstairs is they didn't try to anticipate if and when she would leave rehab to go back home, because if he's there, which he probably has nowhere else to go.
Right. And according to our case, she was there to get her belongings, and that's whenever they came into contact with one another.
So ours is a good case then.
Yes, technically, because it's based on the MOAP that wasn't amended, so,
No,
because that's,
no, but they still are having contact.
Yes,
That's the problem.
just as-
Not the fact that he's
just
over.
as pled.
Well, he lives there. She came over to get her clothes because she was kicked out. It's his mom's house of 40 years.
Right.
Yeah.
Right.
And then she came,
And his mom is a complaining witness.
no,
Who's a complaining witness?
Complaining witness.
he moved
a
in
roommate.
basically to crackheads to the house. And it's a guy and the girlfriend. And then the girlfriend had to leave. And then the boyfriend of that girlfriend, it's not him. So basically he moves in two buddies, two friends.
Right. I get that. So it says here,
And the woman is the girlfriend of the,
one guy.
Yeah, one
So
guy.
That's Miss Scott.
Yes, Judge.
yes,
So that's, Miss Scott's not.
not his
not-
mom.
not his
It's
mom.
not his mom.
Good, good.
So Miss Scott, they're going to get her clothes.
Either, I don't know, I can't tell from the pleadings and what I've read, if it was before she was in rehab, after she was in rehab, or during rehab, when she goes back over there to get her stuff, because somebody, it indicates that someone told her she could no longer live there.
So it says here, did violate said order by intentionally and knowingly going to or near a place specifically described in the order to a residence of a protected individual, namely this address, right? I mean, if you're telling me that it was amended to where he could go there, I'm going to find no probable cause.
So we understand, because the bond conditions were
Right.
amended in the felony.
You want to take a look just to make sure?
Absolutely, Your Honor.
Because it will affect an upstairs case.
Absolutely.
Howell.
And Judge, what we have, and just to be clear, the bond conditions were
In place.
amended.
Yes.
The MOAP was not amended, and that's what this media is based on. Just to make sure that the backs are.
And then according
There's two.
Was that an oversight on their part upstairs?
It appears
We
so.
don't know.
It may, probably was.
There's no note anyway.
But the bond conditions were amended for him to be able to go back to this.
To that same residence, Your Honor, yes.
And they removed his ankle monitor as well, so there was no exclusionary zone anymore.
And here's the rub though, they're holding him at no bond upstairs and then now for another 2 more days.
But the bond is removed.
I'm gonna find no PC. I mean, I can't,
This might be one I need to kind of go talk upstairs about.
do you want to email them real quick and see?
So
I mean, we haven't,
the DVD prosecutor did come down, and basically he was saying, obviously it all depends on the felony, but he also indicated that the MOAP was still in place when the alleged.
Yes, Your Honor.
every right to be there because they amended the condition for him to be able to go back.
But I think they're saying the offense occurred before the amendment was made.
That's a different story then.
Yes, Your Honor. And so
Say that they amended the condition.
sorry, Your Honor, the other thing is this is a,
February 14th, and this office date
Oh.
is.
So what happened is when he went to the location, he got a bond violation. And so he appeared in felony court after that, and they amended it.
But he's still nevertheless,
Right.
Your Honor, before, I just asked for before
I'm not going to.
decision
Because this is the date, but it's the date before the conditions were modified. He still is going there when he's not supposed to be
Okay.
there. Right, okay.
But I was asked if he would reduce his bond.
It's at $500.
I know, can you reduce it to 100?
Let's do this. I don't know yet, because obviously he's still doing whatever he wants to do. And I have concerns, Why don't we set this for the 20th, which is the day after felony court? Let's see what happens over there. And if they give him a PR bond and if they're okay with releasing him, then,
Your Honor, this is a DVD case as well, and so I'll have the DVD prosecutor.
okay, yes.
Okay,
So
so we're gonna roll it to the
I
20th.
would say, yeah, Thursday's the 20th so that we can,
Sounds good. All right, thank you.
I mean, if it was after, I'd find no problem because all day. No,
All right, thank you.
yeah. Ready?
Yes, sir.
Hi, Mr. D.
Thank you, Judge.
Thank you.
Your Honor, I am here on Miss Jessica Sanford. It looks like Miss Sanford picked up a felony offense while on bond for your case in your court.
Okay, I'm gonna have, let me talk to them first because I need more time with you.
Yes, sir, Judge.
If you don't mind. All right. You ready? Are you ready? That's okay.
Mr. Matthew. Shh. It's a bond violation.
What's the last name?
Leonard. We owed them from Friday. Yeah.
Come up, Mr. Leonard. As of 3/4/25, you failed to get a portable device. When did you get it?
I got it, this is the second one. I had to take, my first one because it wasn't registered, just like this one's doing.
So, Your Honor, the long of it all is initially he had an order for an interlock. Doesn't have a car. This case happened. The date of the incident is like years ago. There was an accident. It was a 2B because he was hospitalized in the accident. There was a blood draw, determined that he was over the limit or whatever. So he comes to court and he's ordered to get an interlock, doesn't have a car, tells them he doesn't have a car. There's a bond violation filed.
The first one is because he doesn't have a car, so he just decides not to get a device, right?
No, Your Honor, I believe he was telling him, I don't have a car. I mean, in all fairness, I don't believe he knows that he's supposed to then say, hey, can we do the portable or something like that? I don't believe that I don't believe he understands that. I mean, now obviously he does because I think maybe about a week or so later, he was ordered to get the portable device. He went and got a portable device. There were some issues with the portable device, and that's where this issue is coming in. He was supposed to get it by the 4th. It didn't come in until the 6th of March. And so he's gotten it. I've talked with the pretrial. She said there hasn't been any positive blows on it, but he's still saying that it seems like it's not recording right or something like that.
So let's do this. So I'm just gonna put a monitor on your ankle, so I know that there are no issues. You know, I'll pay for it, but I'm gonna put a scram monitor on your ankle, so I know that there are no issues. Mr. Leonard, you must charge this thing on a daily basis. If you don't, if the battery dies,
Yes.
so will your bond. I don't want any more excuses. If you ever have an issue, you have a lawyer, will go to bat for you, but you can't just not do things because of what you want to do. There are orders in place and you must follow them, and that's it. Any more issues, we're gonna have problems. You understand, Mr. Leonard? Okay. All right, we'll continue supervision.
Thank you, Your Honor.
Thank you, sir.
Right this way.
Yes, sir. Thank you.
He's still here on behalf of Mr. Mike Sadari. He's out of town, so he wanted
Oh,
to.
Mr. Sadar, okay.
Yeah, the first one is Mr. Emmanuel. Both of these are DWI, John. Mr. Emmanuel,
With an I or is this with an
E within the John.
They're both on page 6.
Okay,
Mr. Emmanuel, he's been approved for the DWI PTI program. The only thing that's outstanding is the TRAS. We need to get
Okay.
scheduled for that.
great. We'll do that. We'll send him for a walkthrough now. If he's here,
Yes, sir. He's in the back.
figure it out.
And Mr. Figueroa, but Mike texted me that he's been denied. So Mike wanted me to reset it to give him some time to figure out. And it's my understanding the state has made a time serve offer, but I was gonna let
It's
Mr.
180 days old.
Yes.
Week.
Okay, Your Honor.
And then let Yoshi know he's got to be here in a week to decide what they want to do.
Reset for a week, on? Okay, all right, thank you. May I have excuse, John?
Yes, sir.
Thank you.
So, and then on Emmanuel, we'll set it for like 2.5 weeks
Okay, Your Honor.
to
Okay.
get the interlock, the results of the TRAS and all that stuff.
Okay, Your Honor.
Yes, sir.
One week on Figueroa.
Clear trial. Okay, hey, you ready? Okay, I'm gonna skip you then, and then we'll, come on, you ready? Hi, good morning. Sure, I guess so. It's on Dean. Thanks. While we're waiting, anything else?
I
Okay,
think
let me
that's
talk to them real quick. You ready? Come on.
Melissa Wilson.
Okay, okay. Marissa Wilson, come up.
Follow Mr. Manuel first.
And then.
Ms. Wilson, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 180 days in jail to be probated for 18 months. As part of this agreement, you will do a DWI education class. Is it a true first state? You will do a true first. You will do a DWI education class. You will do, I guess there's no victim impact panel. You will do a TRAS, which is an evaluation to see what other conditions you may need. If they assess other conditions, you must fulfill them. Random urinalysis, no drugs, no alcohol, guardian interlock, 20 hours of community service, and a $100 one-time donation to the Houston Food Bank. Is this how you understand this plea bargain agreement? You need to understand that you're here on a bond violation today because you failed to appear for a drug test. If you do the same thing while you're on probation, I will issue a warrant for your arrest. And we're going to have a hearing as to whether you're going to be doing 180 days in jail. You have to do stuff on time and you can't skip. I don't care what's going on in your life. If there's a choice between probation and something else, what is the choice that you have to make? Right. Because if you don't, you could be facing a lot of time in jail, and then you're not going to have your dog, you're not going to have your work, you're not going to have office. It doesn't matter. Probation is for a reason, and when you don't do probation, there are serious consequences. We issue warrants put people in jail, bring them out in orange, and we have a hearing to determine whether you violated. And if you do, by testing positive, not doing your stuff on time, testing positive, you're looking at a ton of time. The other thing that you need to realize is that this DWI will be going on your record, and it's going to be there forever. You ever get pulled over in a car and an officer comes to you and they smell alcohol and they run your record and they see that you have a DWI, it's probably not going to go well for you. From now on, you're also facing a minimum of 30 days in jail. No more proverbial slaps on the wrist. Do you understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, there's no changing this. This is what you want to do. How do you plead to the offense, man? Guilty or not guilty?
Guilty.
I'll find you guilty. Do you know what happened on the ALR hearing? Can you run our license, please, Alex? What I'm trying to allude to is that I don't know what has happened with your license. I'm not going to suspend your license, but it's very possible that it got suspended through the administrative hearing versus DPS. If it did, your license and it is suspended, you're not allowed to drive, and that will also be a condition of your probation.
There's a current ALR suspension, Your Honor.
So your license is currently under suspension. You cannot drive. If you drove here, you can't drive home. It's suspended. Do you understand? So get the license back. Do you have children, ma'am?
No.
Okay. All right. Good luck to you.
Thank you.
Thank you.
Thank you, Your Honor.
All right. Coming up, gentlemen. All right. So who is Mr. Zion? Mr. Zion, you are wanted out of the state of Louisiana for felony carnal knowledge of a juvenile and misdemeanor sexual battery. Are you waiving formal extradition, sir? Mr. Dean. You were also wanted out of the state of Louisiana, you for second-degree murder, attempted second-degree murder as alleged. Are you also waiving formal extradition, sir? Okay, good luck, gentlemen. Thanks, guys.
Judge, on that, do you want them to pay the DPS fine as well, right?
No, hold on.
Wait, okay. Yeah, I don't
know, I just chatted him.
Okay.
Speak with. All right, good morning, Mr. Torres. Sir, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 1 year in Harris County Jail to be probated for 15 months. You will do a repeat offender DWI education class, 2 victim impact panels. You must also do a TRAS to see what other conditions you may need. You must fulfill all those conditions. If you don't, then into jail you will go. We will have a hearing. You will be facing a year in jail. You must do a TRAS, no drugs, no alcohol, guardian interlock, and 25 hours of community service. Is this how you understand the agreement, sir? You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you accept this agreement, there's no turning around. What happens on the next one? What happens?
Jail time.
No.
Enhanced, yeah, felony.
Prison time. 2 to 10 in the penitentiary is what you will be facing if you ever pick up another DWI. If I were you, even a sip of alcohol, I wouldn't get into a car. You need to understand that this is big business in Texas. And now there is also a surcharge that you will be required to pay because of this. Is it true or untrue that is a 0.15 or above? True the enhancement. You will be required to pay the $4,500 surcharge plus court costs that will be assessed in this case. And I'm going to tell you now, if you don't, every $100 that you owe, you will sit 1 day in jail. Do you understand?
Your Honor.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you accept this agreement, you are stuck with this. You can never change this. You understand?
Yes, sir.
Is this what you want to do?
Yes, Your Honor.
How do you plead to the offer? Or how do you plead to the agreement?
Guilty.
What does he have now? Does he have a guardian in law?
Yes, he does, Your Honor.
I'm going to find you guilty. I will send you to the agreements. Good luck to you, sir. Thanks, sir.
You get the case number?
No, I think
Okay.
it's over.
I had it open, that was maybe she has it. It's 2522036. Okay.
Hey, Mr. Messina.
Señor Lucina, buenos días.
Mr. Messina, you were
Señor Mess-
charged with assault of a family member. You are facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they are offering you 45 days in jail with credit for the 15 days that you have done.
¿Y ya se rió?
You need to understand
Necesita que
that there is an affirmative finding of family violence in this case.
el caso que ocurrió.
What that means is that you can never own a gun or ammunition as a result of this case.
Arma de fuego o munición por este caso. Okay.
Also, if you ever pick up another one of these cases again,
Caso como
you will be
este,
facing a third-degree felony. A minimum of 2 years in prison,
lo
a
mismo.
maximum of 10 years in prison. You understand?
¿Usted lo entiende? I understand.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law.
Bajo las leyes federales. I'm a citizen.
You give up the right to appeal.
A una apelación.
Once you accept this agreement, you're stuck with this. It will go on your record. It will be there for the rest of your life.
Vivir por todo su vida. Understood.
Knowing this, do you still want to go through with this plea?
Sabiendo todo. ¿Quieres seguir con esta declaración? Yes.
How do you plead to
¿Cómo
the
te
offense
declaras a
of
la
assault of a
ofensa?
family member? Guilty or not guilty?
Guilty.
I will find you
Voy a
guilty.
hallarlo culpable.
I will send you to the agreement. Does this take care of the case upstairs? As a result of you pleading guilty to this offense, the injury to the elderly that you have, the felony case is going to get dismissed. I will tell you now, there's not many times that agreements like this will be offered. So if you are a person that has lack of self-control issues, find another way
Averigua
to deal with the aggression.
para
People,
la
children, that's not the right way. All right? Good luck to you, sir.
Buena suerte.
Thank you, Mrs. Saldana.
Thank you, Judge.
Okay, are you ready, Ms. Strong?
Aquí.
So let me come up.
Jogi, David.
So let me get this straight. You plead guilty last week to a terrorist threat. I told you as part of that not to go back to the location. The day after you get out, you go back to this location, you pick up a violation of protective order, and now you want me to take a time served? Really?
Your Honor, sorry to interrupt. It's not a time served. It's a 1 year in Harris County Jail. That's the maximum sentence. And I spoke to the complainant. That's what she's requesting. And
Okay.
Yeah.
But first, I would like to have him TRASed because I want to know how to go forward. Because the problem is that this has now become a revolving door where it's in and out and over and over and over. We need to figure out why. And this, the fact that you just keep going to jail over and over and over, why? Let's get to the root of the problem to figure out why. Why do we have these aggression? Why do we have you keep coming back? That's what I'd like to do. Enough of this, you know? So please, I'd like to set it for a TRS to see how we go forward to figure out, so we stop. I mean, literally, Mr. Lopez, and I did this with you last week.
I understand, Judge.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16. No. The time has come to stop. Okay, thanks. We'll try to get it done as quick as possible. Well, I'll expedite you because you're in custody. Just be honest with these people. They're gonna come evaluate you. Be honest with them. If I get the report back and it says that they're little bunny jumping in the woods, that there's no issues, I'm gonna send you right back to do it again because it's just not true. Okay, thanks. All right.
Your Honor, I am here on Miss Jessica Sanford. We had Miss Jessica Sanford here on an assault case. She picked up a felony PCS, Judge.
Ms. Sanford.
You can't come to court like that no more.
Did you think you were coming to the club today?
No, sir.
This is a courthouse.
Yes, sir.
I don't see a disco ball, man. For real.
I just got off
Don't come
work.
like this again.
Yes, sir.
I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs. And I want to send you for a test now.
Yes, sir.
I want to know what, if anything, that you're going to test. And if I find that you pick up any new cases, I'm going to go absolutely bonkers on your bond. Do you understand me?
Yes, sir.
I'd like to send her for a test now and have her come back.
Yes, sir.
Judge, also she spelled on her second no-show for copy. She spelled to appear twice.
I called them the day of, and they rescheduled it for April the 14th.
Can you verify it? Can you
Because-
verify that?
Yes, sir.
We'll now make that a condition as well. Okay,
I'll send an email.
please. Okay. Mr. D, or John D, come on.
Judge, I am approaching you on Ms. Crawford. And there are two things, Judge. There was a BVR notice sent a few weeks ago, and she
here?
Yes, she's there, Judge. She's in the, you want to bring her up, or do you want me to just? It was for a.
Sent her for a test as well. She failed to go for one.
Right, Judge, just want to let you know that she didn't have transportation, her car broke down, but she went right back the following day to try to do it. And it's all documented, she emailed me and all that stuff, I mean, text me. No, right, so I told her that, and so she did try, it's my.
Come up, ma'am.
Judge, she was set for a drug test already.
Okay.
For Crawford?
Yeah.
Negative.
It's negative drug test, Judge. So.
Thank you for testing negative. Good job. The next time you miss, don't.
Yeah.
You have a lawyer. We've given you a lawyer. If there's ever any issues, reach out to him and he can help you out. If they call you again and you miss again, it's not going to go well. Okay? All right.
Judge, the other thing I want to let you know is she is like, PTI bound. We had a miscommunication because she sent me her application, but it went into my junk mail. So I never got it, but I found it today. We just need a little bit of time for me to forward that and not do it.
Yeah, you got it. Okay.
Thank you, Judge.
Thank
For application?
Yes.
We can do it. Go ahead.
Well, I've got the application.
No,
It's done.
Oh, it's done.
I need
It's
to,
submitted.
right, because.
Okay. Guys, you ready? Thanks for being patient.
Yes.
Of course.
It's going well, Judge.
Tell me something nice.
Yeah, Judge. We're here on Disaki, Dissake.
Okay.
He's getting us mitigation, Judge. He's in good contact.
No, you've had it till December. He doesn't have it done still?
He's gotten some things in.
Please, is it yes or no?
To me today. No, Judge.
And I'm rolling it to tomorrow. And I'm going to roll it every single day until he gets it done.
The only thing I asked, Judge, is I'm out of county tomorrow. Can we just at least,
Zoom.
can we do it Wednesday? But it's not a,
He's gotta be here. You can Zoom. I have Zoom for you, but since December, we're now in March 17th.
and
You want a back rub too?
I can,
Really? Not you.
I can't make him, I can't make him.
No,
Judge.
he's coming back tomorrow and every single day until he gets it done. Okay,
Hold on a minute. Thank you, Judge.
I love you, man. All right, ready?
So reapproaching on Mr. Gonzalez, Judge.
Okay.
Two things going on. Initially, Ashley denied him because she said that he had no insurance.
No insurance at the time.
She said according to a police report, he had no insurance and he got into an accident, that's why I'm denying him. I talked to my client, he did have insurance on that day. And the insurance company tried to get a hold of the CW, was unable to. I emailed Ashley this morning a copy of his insurance and a copy of the response from Geico saying,
Okay. So why don't we just set it for a couple days to see if she'll
see if she responds.
respond and.
That's fine.
Monday, Wednesday?
Yes, and the reason why I waited to now, because I was hoping she'd respond. I sent it to her about an hour and a half ago.
We'll set it 2 days and give you, hopefully that's enough.
Okay,
for her to-
is it okay if I waive my guy's appearance? Because he comes every time.
But if she still denies it, we gotta set him for later in the week so we do something.
Perfect, sounds good. Thank you, Judge.
You have an arraignment. You have an arraignment.
Oh, Judge, I've got an off-docket matter asking the court to set bond on a case, please.
Hold on. What's your cause number?
It's going to be Jaden Bolding. His cause number is 255-4634, 255-4634.
Okay, give me a second. Let me make sure everybody
Yes, sir.
gets it. You got it?
Yes.
No. 255-4634.
255-4634. Yes, sir.
34. No, 4634.
Okay.
Okay, you want to bring your client?
Yes, sir.
I'm sorry, what was that case number?
255-4634. It's an off-docket arraignment.
We need a PSR on that one.
Yeah. Good morning, sir. Give me one second. Did you hear that?
Yes, I got it, but I haven't done the PSR.
Take it up. All right, good morning, Mr. Bowling.
Good morning, Your Honor.
Mr. Bowling, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On March 7th, 2025, in Harris County, Texas, officers were dispatched to a mental health call and met with the witness and the complainant, who are the stepfather and mother of the defendant. The witness stated that the defendant suffered from an undiagnosed mental illness, which caused him to get triggered. The defendant was triggered by clothes lying on the bed and started to argue. The defendant grabbed a pair of scissors, which the complainant took from him before the defendant struck the complainant several times, causing pain. I'm sorry?
Struck who?
The complainant.
I know. Who is?
Stepfather, Your Honor. The stepfather.
All right, Mr. Bowling, I'm going to find that there's sufficient probable cause to go forward with your case. I am now entering in what's called a magistrate's order for emergency protection. This is a court order that identifies Mr. Lawson as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate threat or harassing behavior. You cannot be in possession of a weapon. This usually comes with a residential restriction. We need to figure out, are they here?
They're not, but the state has
Your Honor,
conferred.
We have spoke with them and the complainant does want the defendant back at the residence.
I will take off the residential restriction.
Thank you, Judge.
How old are you, sir?
I'm 27.
You are not to consume alcohol, illegal drugs, or unprescribed controlled medication. And I'm telling you now that I'm going to test you for marijuana. If I find that you're using, it's not going to go well for you. Do you understand me?
Yes, sir.
I promise you, you're going to get tested. If I find that you're using, I will revoke your bond, put you in jail, no more PR bonds. I'm going to give you a PR bond today so that you don't go to jail. But if I find that you become a danger to my community, I will do everything in my power to protect every single person. I don't care what your excuse is. I don't care what you're going through. If there are issues Now is the time for you to take care of them. I hope that this is enough of a wake-up call that I don't have to put you in custody, because we have enough people in there now as it is. What do you do with yourself?
Yes, sir.
Are you in school? What do you do?
I'm planning on going back to college, sir. But I cut hair and I produce and I engineer music, sir.
Okay.
Let's work at
You graduate from high
Oh,
school?
and I work at HEB. Sorry, that was HEB is like my job, but it's in career.
What about high school? Did you finish high school?
Yes, sir. I graduated.
It's time for you now to also start thinking of the future. The more education you get, the more money you're going to make in life. And I'm going to tell you, this life is so great if you have money, and it's so terribly awful when you don't. I promise you. The farther you go, the more knowledge you get, because knowledge is power. This is what you're going to get. This is not good. Now you have a lawyer. Have you signed on yet?
I will today, Judge.
I need you to sign on. I have attorney of records in the tower. You have a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court. But you've got to stay in touch with him, and he'll tell you if and when you have to come back. You're going to get tested. Don't use. You understand?
So
Okay. Guys, Bond, any recommendation?
We would ask for maybe a $500 surety bond, not anything
Do you have any priors?
Yes, no priors. No priors, Your Honor. And due to the mental health concern of the case, we wouldn't.
Surety bond's going to do what?
I spoke to the DVD prosecutor as well, and that's what he conveyed.
Well, I'm going to give you a PR bond. I'll set your bond at $100.
thank you, Your Honor.
Just make me proud. That's all I'm asking you to do, man.
Sir.
So what we're going to do now is I'm going to have you go sign a reset with Victoria. We'll have you take a seat while we generate all the paperwork. You will meet with Felicia for your bond conditions, and after that, you're free to go.
Very good.
Thank you, Judge.
So can you file no threatening, harassing, and no weapons, please?
Yes, sir.
Yeah, no. I want him to sign them up, but let's do everything all at once. Oh, wait, no, don't file it because he's being
Being
monitored.
monitored, yes, Judge.
Nothing needs to change in the law, correct, Judge? If you say,
No, take off the residential restriction. Okay,
Judge Miss Moreno on today's docket, Judge, she was set for the 26th of this month. Because she missed a drug test, we moved her up to Friday. She took a drug test Friday, and it was clean. I was just saying if we could move it back to our original date of the 26th. She was having trouble getting here today, but she was here on Friday and did post negative. You were sent an email on
if she's
Friday.
negative, I'm cool.
Just take her.
Okay, so far, you ready?
Should I call him up?
What's the name of your client?
I'm sorry, last name is Munoz.
Okay. Okay, what was the last name again?
Munoz, Fuentes?
Oh, Munoz Puente. Okay, right, okay. Shh.
What's the case?
Mr. Munoz Puente, you are charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine.
Dólares de
You're
multa.
going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, sir. On July 4th, 2019, the officer observed a white Ford Mustang pull out of the Citgo gas station parking lot onto the 200 block of East Little York Road. The officer observed the Mustang fail to drive in its designated lane, driving over the striped white line in between lanes 1 and 2 multiple times, while other vehicles were on the roadway. The defendant was unable to control its speed and accelerated and decelerated multiple times. A traffic stop was initiated. The defendant was observed to have red glossy eyes, slurred speech, and swaying while he was standing. The officer also observed a strong odor of an alcoholic beverage. The defendant admitted to drinking 5 beers, and standard field sobriety tests were administered. HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 3 out of 4. 2 spilled beers were found in the vehicle, and a search warrant was drawn and executed for the blood.
Why is this case 2,083 days old?
Just so speaking to him in 2019, he was arrested in an ICE detainer that was hit. He was picked up by immigration. He said when he was in the immigration court, they told him he could sign a waiver.
Voluntary departure?
Yeah, voluntary departure. That's what he did.
Mr. Munoz pointed, you want to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medications. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond and I'm going to put you in jail. I don't know what your immigration status is now. You now know what happens when you go to jail. They will possibly deport you. And I'm going to tell you, if you come back and you don't come back with the proper documentation, it could be 5 years minimum in federal custody on an illegal reentry charge. So when you do things the right way, good things happen. When you don't, there's serious consequences. If I find that you violate any of these conditions, I will put you in jail. Do you understand? On his license, see if he has a valid license, please.
There's no license on file, Your Honor.
You are not allowed to drive. That is my most important position in this area now. If I find that you drive, I don't care what you I can have a contempt hearing. You can be facing an additional 6 months jail and $500 fine. I will have you sign with me now an affidavit. This is a promise that you're going to make to me that you're not going to drive. I don't care what is going on in your life. If you don't have a license, a Texas license, and liability insurance in your name, you are not allowed to drive. You run his NCICC as a priority to the guys, please.
Yes, Judge, I'll run it.
Your case number? It's 226-7399.
Your Honor, it appears based on the NCIC, there's a pending DWI out of Dallas County as well.
That's correct, Judge. He does have another open DWI in Dallas County. We did pick it up before this case. But it was a warrant for both of them, when she was picked up for, when he paid bond for both of these cases. So before he was deported, he had picked up both those DWIs.
Did he get a PR bond in this case?
Case number, Judge?
Munoz pointed.
GOB, but it was
First row,
Cuando revocaron atacante
and then he posted
que faltó
a
en el 2019. Cuando pienso, efectivo.
I'm going to put an ankle monitor on
Voy a
you,
poner una
and I'm now giving you a
y
code
le voy a
7 to
dar
7. If I
un
find that
horario
you're out
específico.
past
Si
7
usted
p.m.,
sale después de las
I'm
7 de la noche,
I will do
voy a
everything in my
usar-
power
voy a
to
hacer
protect
todo
the
lo que
community at all costs. Do you
lo
understand?
entiendo.
It's
Yes.
unacceptable. Counsel, were you going to say something? If I find
Y yo averiguo.
that you test positive for anything, and I don't care what it is, if you try to come here and try to tell me that it's mouthwash, it's a tequila lollipop, it's hair dye, it's mustache ointment, I will literally
Reporter.
find that you are driving a car. Holy moly, I will absolutely lose it. Do you understand?
¿Lo entiende?
Don't dare
Te atrevas
get near a car.
a acercarte a un automóvil.
So 7 to 7 curfew.
De 7 horas en su trabajo.
Scram monitor. No alcohol, no drugs. Is all discovery in?
Yes, Judge, everything did.
Okay, so counsel, I'm gonna give you a 30-day setting. At that point, you gotta come back and let us know what you want to do. And then you have 30 days to go through all the discovery with your lawyer. And you come back at that time, I'm gonna either set your case for trial or you will accept the plea bargain for the agreement. But at 2000, and I know that the issues may have happened, but with another DWI open, it's time to do something about it. Okay, all right.
Thank you, Judge.
See you soon.
Judge, we have a
Okay, she's been waiting. Let me hit. Are you ready?
Yes, Your Honor. He tested positive. He requested that he do the drug test. He did test positive, but we were waiting.
Who are we talking about?
Gallegos.
Come up, Mr. Gallegos.
Yes.
So when was the first time we tested him?
I believe February the 13th. I'm sorry, not the 13th. It was 2 weeks ago.
2 weeks ago. I have a note from the 10th saying that he tested positive for THC. We were just awaiting to see confirmation from the lab.
The lab confirmation was not come back.
When did we first test him, please?
Judge, 1 second, please. For Diego?
When was the first, we ordered him not to use when he first got here, correct? But this case has been on docket for 64 days and you've continued to use. I've ordered you not to use. You just tested positive. You first came here 64 days ago. I ordered you not to use and you tested positive yesterday?
Sorry, Judge, it's loading.
Take your time.
I have positive on January 17th and then a positive on 3/10.
He was, I know, I understand the test, but my client's very comfortable with me and he was quite confused as to how the results came up positive because
I can tell you why. Hey, I'm revoking your bond. You're going into custody. He goes with you. I told you. And here's what we'll do. We'll give it a couple days. I'll admonish him. Let him out. And clean out. If he cleans, great. If he doesn't,
He goes back in. Can a couple days be like Wednesday?
I'm okay with Thursday.
Okay.
Yeah, for sure.
And for Baptiste, I had filed a motion to withdraw in your queue.
Is he his own land?
Huh? No, he's not on docket. But he doesn't have an attorney, so I don't know if the court wants to appoint. I'm just like.
I don't see him in the dock today.
Oh, he's not. I'm just.
No. So we got to get him on the
Oh,
docket.
he's on the docket. And then you-
Right. I don't just grab